Good morning, ladies and gentlemen. For the second half of this morning's session, we will have a panel debate, or rather panel conversation, I suppose it will be, on the new ways to protection in the EU and dealing with the developments with the Common European Asylum System. For that, I'm joined by three eminent speakers who are certainly very much aware about these developments from different perspectives. I'd like to introduce them to you to start off with Sophie McGuinness, the head of the Policy and Legal Support of UNHCR representation for the EU here in Brussels. Then we have Stephen Ryan, who's the deputy head of the unit Asylum at the European Commission, and Dirk van den Bulck, who is the Belgian Commissioner General for Refugees and Stateless Persons. On behalf of the organizers, I thank you for your participation already in this panel debate. Due to this international composition of the panel, you will forgive me that we will conduct our proceedings in English, but feel free later to ask your questions in the language of your own preference, of course. We will talk about a number of questions that you have seen in the program already, dealing with the Common European Asylum System. And since not everybody is really working in the field of asylum here in the audience, I'd like to sketch out very briefly the ABC of this CAS that was initiated at the famous Tampere Council in 1999, almost 20 years ago, where the ambition was set at, in a long time perspective, the European asylum system would have to result in a common asylum procedure and a uniform status to be attributed among the member states of the European Union. And as you know, between 1999 and 2005, the first phase towards this elaboration of a common European asylum system was initiated by looking at common minimum standards in different fields of asylum, and also looking at measures of financial solidarity among the member states. And this resulted already in a number of legislative instruments that have been adopted in that phase. Then after this initial phase, which also required for a very long time unanimity among all the member states, it was time for reflection. You will probably remember that there was a consultation with the public with a green paper that was presented in 2007. And then in 2008, the Commission developed or presented its policy plan for a second phase where they were striving to go to more harmonization of the standards of protection, where effective and practical cooperation among the member states and with the EU was provided, and also the famous solidarity and responsibility among the EU, but also between the EU and the third countries, was set out as important goals. And this resulted once again in new legislation with revised directives on the procedures, the asylum procedure, on the reception standards, on the qualification for international protection, on the Dublin regulation, and on Eurodac, everything that has to do with fingerprinting, and that ended in 2000, or the aim was to deal with that towards 2012. And then came 2015, and I'm not still up till today, I don't know whether it was an asylum crisis, whether it was a migration crisis, but I think everything got mingled there in 2015 with the influx of people in Europe, some of them applying for asylum, people making crossing over the Mediterranean in very unsafe circumstances, with the whole Dublin system that seemed to collapse, with people traveling on from one member state to another without respecting the responsibility that was set out in the Dublin regulation. And some have argued at that point that 2015 witnessed the flaws that were both at the legislative and at the operational level present and baked into the DNA of the Common European Asylum System. It was obvious that it was very difficult to register claims, to come up and fulfill the reception needs that were present there. It was also clear that in terms of applying the minimum criteria on qualification, that you saw differences, and up till today you see differences in the application of the definitions of international protection, subsidiary protection. I think that also the map that was shown earlier this morning with the differences in recognition rates among the member states concerning the same nationalities is a good example of this divergence that exists. And there are also differences in the procedures, and that all comes from the fact that the directives leave still a considerable amount of discretion to the member states. As a result, or in a reaction to that, in April 2016, then the Commission communication on reforming the asylum system and developing safe and legal pathways to Europe explicitly was targeted at building a fair and sustainable asylum system. And it set out a number of goals. First of all, the Dublin regulation would have to be made more sustainable, and a fair system for determining the state that is responsible for determining asylum claims. A reinforcement of Eurodac was provided, so that this instrument and the taking of fingerprints and data could also be used to identify irregular migrants and to be useful as a tool for return, which once again indicates that there's a mixture there between the theme of asylum and migration. Greater convergence in the European asylum system was forecasted, and the idea was to leave the path of directives and move into the path of regulation, so that you would have, or will have, hopefully, uniform legislation throughout Europe, both considering the asylum procedure and the procedure for international protection and the qualification. Prevention of secondary movements, which has been a very hot issue the last years, and where you see that people move around during, after, or prior to applying for international protection, is being looked at. And finally, a last objective was to initiate a new mandate for the EU Asylum Agency, so that they could, for instance, issue guidelines for specific countries of origin or intervene in emergency situations in a way that is comparable to the European Border and Coast Guard. So a very ambitious program that is being developed now. We have 1 hour and 20 minutes to talk about that. It will be impossible to cover all the issues that are present in the asylum system. We've picked out a number of themes that you've already seen on the agenda of today, and I would like to invite the members to give their ideas, and perhaps we can start with a more general question on the common European asylum system. Are we moving forward, or is it moving in towards a direction of a complete impasse, also taking into consideration the differences that member states seem to take in the approach of asylum, where some seem to go for an idea or a model. Sometimes it's being called also in the Belgian context the Australian model, with an externalization and a strong control on who is going to get in. Whereas in the scheme work that has been provided so far, the internal protection here in the European Union is still a very important element in this asylum system. So where are we going to head with that? And perhaps to open up the discussion, or I would like to pass the floor to Stephen.
Thank you very much. And also thank you for this, I think, excellent introduction to the history of the asylum system here in the European Union. To answer your question, I think before we become too despondent about the slow pace of progress over the last couple of years since the Commission adopted its reform proposals, I think it is important to step back and look at what we have achieved, and you've explained that very well, very succinctly, how much we've achieved over the past 15 years, and that's a relatively short period of time. We've had 2 generations of asylum legislation, as you've just very well explained. We have an agency which is rapidly growing and which is active in several member states in providing operational support. We have a very sophisticated system in place, sophisticated legal framework. We have a system that has dealt over the last 15 years with several million asylum applications and granted protection to hundreds of thousands of people. So we're not talking about a system that is not working. But having said that, I think it is true that the crisis highlighted that there are some very important shortcomings, especially when it comes to the sharing of the burden, if you like, within the European Union. And indeed, we diagnosed already at the beginning of the crisis in 2016 that there was a serious problem there. And we proposed a very radical overhaul of the Dublin system. And I think it's important to keep that in mind. We took the view that it was, to a significant extent, a dysfunctional system and an unfair system in the way that it was constructed. But what we proposed was radical because it involved compulsory relocation of applicants once certain thresholds were exceeded. And I think it's perhaps not surprising that it has not proved easy to reach agreement, especially when agreement needs to be relatively consensual for it to be politically deliverable in the European Union. It's not surprising that it has taken that long. That's not to say we should be complacent or to lose our sense of urgency, but I think we should not give up hope. And I think we have. I mean, it has been a frustrating process, the discussions on the Dublin regulation over the last couple of years. But at the same time, I think it has been useful in identifying what are the red lines, if you like, of some member states. And the Commission, in its communication from last week, has indicated what could be some lines for possible future compromises on this issue. I think we would like to avoid the toxicity of indicating that there is compulsory relocation triggered automatically when certain thresholds are exceeded. And so we have, I think we have proposed that reflection should be made upon a more, let's say, a more open approach where member states would have a certain discretion in terms of the form in which they would provide solidarity in certain situations, but always in a way that ensures that member states that are under real pressure are provided with a real guarantee of support. And then where this will end up, we simply don't know. My hunch, of course I remain professionally optimistic, my hunch is that we are not going to see a very radical change in the Dublin regulation, but something more incremental, something more organic, something hopefully that is significantly better than what we have today. But it will probably disappoint many in terms of what it will result in when it comes to the voluntary relocation aspect. But I say that in my personal capacity, not in my professional capacity. And then just a quick word on the rest of the package, not to neglect it. We, as you know, in 2016 we proposed also to amend the rest of the legislation, and as you said, even to transform 2 of the directives into regulations. A lot of progress has been made on that, and actually at the technical level we're largely there in terms of what could be adopted. Not quite, I won't go into each of the individual ones, but we're quite close to agreement. And we hope that at least some of those instruments can be adopted during the lifetime of this Parliament. What we've said in the recent communication is that we think that these are instruments which have a standalone value, and therefore we are encouraging that the package, if you like, the asylum package, could be broken up and that we could, make some progress by adopting some of them. I would single out a couple of aspects of that in particular that we think would have a standalone merit. One is, of course, the agency, the asylum agency, where we have proposed a significant strengthening of the mandate of the agency and of its resources. We think this is something that both co-legislators should be able to agree is a good thing, and we very much hope that that will happen. In September of this year, the Commission proposed some additional changes to strengthen it even further, drawing on lessons that we've learned over the last few years. That has, let's say, complicated a bit the process of adoption, the process of negotiation, but we still remain hopeful that it will be possible to reach agreement on that. The other thing I would mention, of course, is the innovation in our package, which is the resettlement framework. This is something new. It's a new piece of legislation. We think it's a very positive development and something that will provide a stable backdrop for the hopefully increasing commitment of the European Union to resettlement in the years to come. And I know we'll be discussing that later during our panel discussion.
Okay, thank you for your comments already. Then I pass the floor to Ms. McGuinness for your point of view.
Thank you very much. Good morning, everyone, and a big thank you to EMN for having UNHCR here today on this panel as we all look and wait to see what, if anything, might be decided by the European Council, the leaders who are coming to Brussels, and we'll hopefully have a moment away from Brexit to be discussing issues in relation to migration. One of the key things that needs to be discussed at the moment is how states are going to grapple with this question of whether to proceed with the package approach that Stephen was talking about earlier, or whether to divide up some elements of that package. And I think it goes to, it highlights how political and how difficult this question is, that it appears that the Justice and Home Affairs Council have left that to the leaders' meeting to see if some movement can go ahead on that. I think Stephen has given a very good overview, of course, of where things are at the moment. I think that there is a lot of disappointment and disillusionment in many quarters about where the reform is at. And that's amongst organisations that also would have had some difficulties with aspects of the reform. I think there was a real consensus that change was needed, that there were certainly some good elements in the package, and indeed some radical ones that the Commission had put forward. So there is, in certain circles, a feeling of despondency. And I wanted to try to inject a couple of potential positive things that we shouldn't lose sight of while the discussions remain so difficult and the political impasse remains in place. I think the first is that there has, in recent years, and in particular this past year, been a lot of pressure from some member states and some circles to really try and push the European Union in a direction of having a non-entree policy, of not admitting to the EU territory asylum seekers. We have seen some of those approaches and ideas shared by certain member states, and we have seen this message being spoken about quite widely, that the European Union can't cope with asylum seekers, that it's too politically difficult, that they should stay where they are, that the European Union shouldn't receive asylum seekers because the ways that they come here are so dangerous, and that in the alternative, all persons in need of protection should receive that protection in the regions where they are, namely Africa, Asia, etc. And while these messages have managed to garner some support, they have not managed to command a majority of European Union member states. And we still see a commitment amongst the majority of states to the idea that is enshrined at the heart of the European Union, that there is a right to seek asylum, that there is a right to protection, that the protection against refoulement is key and core to the European Union and the European Union member states. So if we're to draw something from that, I think in this pressure that we see at the moment, this intense political pressure, the ground has held when it comes to that core value of protection within the European Union. But we must not, of course, be complacent, and we have to continue to work very actively as UNHCR, together with the Commission and together with Member States, to ensure that through this impasse we do manage to extract a reform that is necessary, and we do manage to protect and preserve the asylum space in the European Union that is so crucial. We also see at the moment a potential for us to build on some arrangements that have been entered into between some EU member states to share solidarity with each other. As some of you may have seen, in October, Portugal reached out to Greece and offered to relocate asylum seekers from Greece. There have been other such initiatives, and these kind of initiatives can function within the existing EU frameworks, and indeed the Commission has been very supportive in saying that they would support Member States in this way, and will also look to support Member States financially by continuing what was made available under the previous relocation programme. This is of course not what any of us wanted. We wanted a predictable mechanism that would work across the European Union, that made it clear what everyone's responsibilities were. And we believe that it's very important to continue to work towards that objective. We see that I think the majority of member states want to continue to work towards that objective. There's just a little bit of realpolitik now that looks like that might not happen before the elections. But we certainly in UNHCR will not be moving away from the need to continue to support a proper, real, European-wide, EU-wide solution when it comes to responsibility sharing and states supporting each other and supporting asylum seekers and refugees. But in the meantime, we also see value in supporting some of these initiatives so long as they are in line with existing EU frameworks, they don't depart from the acquis, and they actually do work to support asylum seekers and refugees, and that their rights are properly respected through those ad hoc arrangements. One of the questions I think that was asked at the outset was, in 2015, what happened? What kind of crisis was it? Was it a crisis of asylum? Was it a crisis of migration? Was it a crisis of politics? And it does appear that the current impasse that we're in and the experience that we've had since 2015 has pointed to the issue being one really of politics, and also possibly the way that these issues and these challenges have been communicated to the electorate. As I understand you heard this morning, the numbers of persons coming to the European Union is way, way down. It's currently lower than the arrival numbers of 2013. The arrival numbers are low. This is known by, we hope, a lot of people in the European Union, because it is being talked about by many politicians. And there was often a narrative advanced that when the numbers were reduced, then EU member states would step up on resettlement commitments. They would step up on intra-EU relocation. They would invest more in asylum. And I think we really have to hold those states to those commitments that they made earlier, to really addressing from a systemic point of view the issues in the European Union when the numbers became lower. Now is exactly that time. The numbers are lower. Now is the time to get the arrangements in place. And in terms of what really needs to be progressed, I fully agree that we need to continue the hard work on the core crunch issue of solidarity. In terms of access to the territory, I think we're going to come on to that in the second question on safe third countries, so I'll keep my comments on that for later. But it would seem that there are two issues that really do need to be advanced. One is the European Union Asylum Agency, currently the EASO, the Asylum Support Office. That agency has been planning for some time now for an expansion in line with their mandate coming in. And that's appropriate for any agency that's going to be looking forward to a big extension in their mandate. They have been planning in the Secretariat and in the Management Board. They have been recruiting in line with this. They have been putting in place and adopting plans. So it really is crucial now that that agency receive the political support that it needs from member states and through the trialogue process, so that the agency can be fully equipped to meet the challenges that are coming. On resettlement as well, and we're going to talk about that further in some of the additional questions, there has been a lot of work put into the European Union resettlement framework. There's a lot of good that's included within that document. We're very keen in UNHCR to see that advanced. We're very keen as well to see a clear focus on the protection elements in that framework, and moving ahead on a framework that will enable and will facilitate member states to coordinate better, to work together in a more cohesive way, and ideally to pledge substantially more places is really key, and in line with the Global Compact on Refugees, which I might speak about later as well, where we need that commitment for much more support. So in summary, yes, the impasse leaves things looking quite bleak, but there are things that we can work on and we must continue to work on, because if one thing is clear, it is that if we are to return to more significant arrival numbers, we haven't learned the lessons yet from 2015 and we're not prepared. And the second thing that is very clear, and was evidence in the most tragic proportions when we saw the recent event with the Spanish fishing trawler, which was left at sea for many days off the coast of Libya with no safe port to put into. We cannot afford to keep stumbling from one boat crisis to the next, to put in place the measures that are needed to save lives, to facilitate the saving of lives of some of the world's most vulnerable. So for those imperatives, we do need to move ahead with the reform and the key changes that are needed. Thanks.
Okay, thank you very much. And I pass the floor to Dirk van der Wilk.
So thank you. Good morning. I will not repeat about what already I said, so a few words, and this then out of my experience as a Commissioner General, Director General of the Asylum Instance in Belgium, and as a member of the Management Board of EASO, so the support office agency that is responsible for organizing and coming to the realization of a common asylum, a European asylum system. So, but first, what I can say that I was, and still am, but I was a believer and a great believer in the realization of a common asylum, European asylum system, step by step. Like Stephen Ryan said, the years and during a long period, Europe, the European Union, has worked out a framework by regulation, by giving courts the possibility of interpretation and leading jurisprudence, by instruments of cooperation between member states, the European office to realize this cooperation. So there were a lot of instruments there to go step by step in the direction of a European asylum system. And a moment, there were a lot of indications that we were going in that direction. But secondly, the system has become under pressure by the situation, what we called the asylum crisis, 2015-16. And there's a lot to say about that, but there are a lot of elements, but important elements I consider that first, that was that instances in many member states of the European Union had become under pressure with a lot of problems of management, organization, lack of financial possibilities, and so on. So the instances, many instances, and this is about the assessment of asylum requests, Dublin, but also the reception of asylum seekers, even also refugees. All these instances has become under pressure. It's one element. Secondly, a very important element also that the political approach has become different. And there are a lot of different approaches, but it's clear that, and a very important, and it's a lot to say about it, but that the ideology from some member states, some politicians, has become more important in the approach of developing policy. All the discussions have been less evidence-based. There has been more problems about solidarity and so on. So there has become a real problem on the political level. That's clear. And that made the system really under pressure, and it makes more difficult, and that's clear at this moment in a way that can say, I think that at this moment we are in a situation of impasse, difficult situation to go forward. Even still, and I see it, and for instance, within EASO, the European Support Office, still working on instruments to realize the common asylum, European asylum system. Even also at this moment, I see within EASO, there is less commitment to realize this than some years ago, for different reasons. So at this moment, we're in a difficult situation, but I still hope, and I think it was already said by Stephen Ryan, I hope, and there are possibilities to take up the line again and to go in the direction, step by step, of a solid European asylum system. But it's clear that a lot of things has to be done. And first, on a political level, and there's a lot, and again, to say about it, but like I said, what I think what we need more, that is an approach evidence-based. What is not evident? One of the problems is that a lot of politicians are discussing about it out of some ideas. Some ideas, these and those, that ideas that not many times not evidence-based, that are far from reality. Many times in that way also not at all effective. Discussion about solutions you cannot realize in that ways, but they present it as possibilities to realize a policy that will be effective, but they are not, because what they are proposing is not realistic, so they do not discuss about points where, or policies, where you can be effective. So more evidence-based discussions. It's easy to say, it's not easy to realize. So, and within this, of course, and I think within the discussion on the European level, a very important aspect is to come to a solution, is to realize solidarity between member states, and to realize this in a system. It is very difficult, and sometimes also I try to think and how we can work out it. But it is very difficult, complex sentence. But I hope that solutions can be found and that we can again take the way in the direction of a solid European asylum system.
Thank you. So still some optimism prevailing with a huge part also for Realpolitik, as you mentioned already. Let's go to a couple of more specific issues that have come up, and you already mentioned them, this idea of not receiving claims here in Europe, but trying to shift the responsibility outside of the European Union is already present, I think, in some of the instruments, and the most evident is the concept of the safe third country, where an application can be rejected for the reason that there is a safe third country outside of the European Union where the claim can be examined. There's also been talks about having more protection in the regions of origin. What are the possibilities there? Are those the cornerstones of a new EU protection model? Are they feasible? Are they realistic? And are we going to have, we've been talking about solidarity. There's this enigmatic Article 80 in the Treaty on the Functioning of the EU about solidarity that is needed among the member states. But are we going to establish that without solidarity outside the EU and between the EU and the countries of origin, the regions of origin? What are the ideas, the issues that can play a role there? Perhaps, Sophie, if you can open up on that question.
Sure, thank you very much. Yes, this issue of safe third countries and protection outside of the EU is one of the most talked about in recent months and years in Brussels. Maybe just to be clear about the scope of the current discussion, as we see it, there is a proposal that for asylum seekers who are arriving to the European Union, that there would be mandatory procedures in EU member states where every member state would first of all check to see if the asylum seeker who's arriving could be sent to a country outside of the European Union that is safe in terms of that country being able to process their application for protection. So that's essentially the proposal that's there on the table. It might be oversimplifying it for those of you in the room who are very much involved in these discussions, but that's essentially the idea, a mandatory check to see if a person can be sent to a third country for the purposes of checking whether they are in need of protection and then granting them protection. We as UNHCR are very keen on working together with states and partners in a comprehensive approach to the issues faced by asylum seekers, refugees, stateless and IDPs globally. And we set out the four prongs of that approach in a document called Better Protecting Refugees in December 2016. And in that document, our approach is basically us calling for the European Union to be more engaged in countries that are producing refugees or to where those refugees flee. So that's about trying to deal with the causes, the reasons why people have to flee in the first place, and ensuring that they have protection as near as possible to them when they do have to flee. That is an approach that we've always taken as UNHCR, where we work to seek to protect and assist people who flee, but we also work more globally to try and reduce the reasons why people have to flee in the first place. So that's a key part of the first element of the approach. The second is that the European Union needs to be more ready in terms of contingency planning. So that goes back to the discussion that we had at the top about having a European asylum system that functions and that is ready for a range of contingencies. The third is that within the European Union, we need a common European asylum system that functions well, and I'll come back to that. And the fourth is a European Union that integrates its refugees well into the community. So those are the four elements of the approach. So we are indeed in favour of building up protection capacity all around the world. That's long been our approach as UNHCR, to support all states. We want all states to sign up to the 1951 Convention on refugee status, and we want all states to have a protection system in place. That's our aim, that's our long-term goal. So that said, protection in the region, protection in North African countries, protection in African countries is key, and we have been and continue to work with countries in developing that protection. When we come to the idea of the safe third country principle, one of the principal issues that we have with that is that if it is described as it currently is in the proposals that are being discussed as a mandatory approach, an approach whereby states would have to do this safe third country assessment, or even, and there have been changes in the discussion now where the mandatory element has been dropped, but still the focus would be on using the safe third country approach, then we have to ask the question, what signal does that send to countries outside of the European Union who are thinking about setting up or enhancing their own asylum systems? Some of those countries might see an ambition from the European Union member states to send back as many people as possible under the safe third country concepts as a chilling effect on them developing their own system. Put simply, there are few incentives for a country to build up an asylum system if it simply makes it a candidate to receive asylum seekers back from the European Union. What compounds that problem is that many of the countries in which we are working to try and develop and enhance protection systems already have existing large numbers of refugees and asylum seekers on their territory. So again, it would not be in their interests to develop protection systems locally if all they can see is the prospect of additional asylum seekers coming. And perhaps compounding the entire thing is the fact that the European Union continues to receive comparatively fewer of the world's displaced than other regions. And I think that's why any use of a concept such as the safe third country concept needs to be fully enshrined within this global idea of countries sharing solidarity together. If there was a trust and a feeling in regions outside of the European Union that this concept wouldn't be overused by the European Union or would only be used in a way that would really assist in sharing solidarity globally, then perhaps we could go somewhere with it. But that's not the signals that are coming from some circles in the European Union. Some member states are talking about sending back all people to third countries and stating that the region can't assist. So we would really warn against using this concept in a way that's going to place a chilling effect on the development of protection space outside of the European Union. So that is principally our main issue in relation to that. And the second and final point I would make on it is that, as Dirk says, we need to take an evidence-based approach to policy making and to policy choices. What does the evidence that we have to date on how the EU-Turkey statement has worked tell us about the safe third country concept? Through the EU-Turkey statement, Greece put in place a safe third country procedure in line with what's set out in the acquis. They changed their national law and they put in place a procedure on the islands in Greece which principally looks to see are people safe, and on that basis can they be returned to Turkey. Now, that arrangement has led to a great fall off in the numbers of asylum seekers coming to Greece, but how has the system technically functioned? And when we look at that closely, we see that to date, we haven't seen returns from Greece to Turkey under the pure terms of that deal. It's been very difficult for the Greek authorities working together with the EASO to secure the return of a person to Turkey on the basis that Turkey is safe for them. So these concepts are often sold as a panacea, as an easy answer, as a way for the EU member states to get around some of the challenges of asylum, but the evidence tells us otherwise. And what we have recommended as UNHCR is that European Union member states continue to receive on their territory the comparatively small number of persons that come to the European Union seeking protection, that the assessment that is done is a merits-based assessment that quickly determines who is in need of protection and who is not. For those in need of protection, they receive protection in the European Union, they are integrated here. For those who are not in need of protection, who don't meet the criteria for subsidiary protection or for refugee protection, and where there aren't other humanitarian reasons blocking the return, they should be offered assisted voluntary return, and if that's not taken up, they should be returned. We need to have return as a system that works in a quality-based system and that underpins the integrity of the asylum system. So we know that that work is difficult, but together with EASO and other partners as UNHCR, we are committed to continuing to work with member states to build up quality determination procedures so that the European Union can determine who is in need of protection and who is not. And we would encourage member states not to be attracted by a notion that seems simple. The evidence shows that it's not simple, and it could also have this chilling effect on the development of protection systems elsewhere, which we all need. Thanks.
Okay, thank you. Mr. Ryan, your view.
Thank you. And actually, I would start by saying that, at least from the Commission's perspective, we broadly share the analysis that Sophie has just outlined, in particular when it comes to the kind of protection model that we should be following here in the European Union. The way we see it, the European Union should be contributing appropriately to the global refugee challenge, and that includes taking in its fair share of refugees. However, what we have been seeking to achieve over the last few years is to move from a model whereby the refugees that we take in arrive primarily in a spontaneous way by irregular, often dangerous routes, and instead can come here via resettlement. And in order to be able to manage that, in order to be able to have a system where, a global system where refugees do not have in their minds that they can freely choose their place of refuge, there is a need for tools like the Safe Third Country concept, and that's what I'll try to explain a bit. But firstly, just to explain this concept of avoiding the impression in the minds of the world's refugee population that the fact that one is a refugee means that one can choose the place of refuge. I think it would be a dangerous path to go down for the integrity of the global refugee system, refugee protection system, if we were to accept that as a premise. I think what you would end up with in that situation is that the countries which refugees would wish to come to, the most developed countries, would find that this is both economically and politically unsustainable, and you would end up in the consensus, the broad consensus in favor of the current refugee protection framework being eroded. And that's why I think it's important to have a concept like the Safe Third Country concept. I think this concept has been, to some extent, overly demonized. Firstly, let's recall that here within the European Union, where we also accept the premise that there shouldn't be a free choice for an asylum seeker or refugee to choose the member state in which he or she wishes to settle, we have a very sophisticated internal Safe Third Country arrangement. We have a multilateral, effectively, Safe Third Country arrangement in the form of the Dublin Regulation. It has many flaws, it's dysfunctional, but in its essence, I think most people agree that we need an arrangement of that kind. We need some kind of an internal Safe Third Country concept. And I think the same is true also at the global level, provided it's used in the right way. It is a useful tool, it is sometimes a necessary tool and an appropriate tool. To recall as well that in European Union law, and this has not changed in what the Commission has proposed, there are some very important safeguards with regard to its use. Firstly, in terms of substance, the Safe Third Country that somebody is sent to needs to be a country that is not going to where the person will not be exposed to harm or persecution or the risk of onward refoulement, where they will have access to protection and to certain minimum standards in terms of their livelihood. There are procedural guarantees that there must always be an individual assessment that a country is safe, where the person should have an opportunity to refute the fact that it would not be safe. In addition to that, there is the condition that there must be a connection. The person must have a connection with the country, that it must be reasonable to send the person there. While the European Union, the European Commission has indicated that transit would be a sufficient connection, there must always be this individual check to see whether it would be reasonable. And as Sophie has said, that has meant that, for example, in the context of the EU-Turkey statement, in most cases, persons have not been sent back. And lastly, there is the condition of readmission. And this is really the critical condition. It's not something that can be or should be used unilaterally, for example, in the way that it's being used by Hungary vis-à-vis Serbia. It's not a tool that should be used to simply dump refugees over the border without the agreement of the state of the receiving state. It's something that implies that the readmitting state agrees. That could be, for example, in the context of an arrangement of the kind that we see with the EU-Turkey statement, which has the purpose of avoiding the kind of spontaneous arrivals that I was talking about. And don't forget that the quid pro quo for the acceptance of Turkey to re-accept those persons involved, among other kinds of assistance, the fact that the European Union would accept to take a certain number of persons in the form of resettlement from Turkey. So it's not that the European Union was simply using this as a one-way avenue for returning refugees. So I think that provided it's used in the right way, it is a useful concept and an important concept.
So as the third speaker, so I will repeat again what was already said, but I think that the concept can be a crucial element in the policy in the future, asylum migration policy. But then, on the long term, for me, it's clear that on the short term, it cannot be a crucial aspect of policy. And it is already said that by Stephen Ryan, the conditions in European law are clear. And taking count of these conditions, it's very difficult. And to come at this moment in the actual context to a decision based on this concept. Like Sophie said already, that's, for instance, it's in the context of the deal European Union-Turkey, it was part of it. But the impact of this pact was not by taking decisions based on this concept. It was on other aspects. It's only in a few cases that a decision by Greece has taken on base of this concept. In Belgium, the concept is, since a few months, also in the law, but till now, 0 decisions have been taken on this basis. No indications that within and in future that there will be decisions on this base. So that taking count of the conditions, and it's good so, that in the actual context, it's very difficult come and using this concept in a policy. in that sense, I consider it also as counterproductive to put forward this as a crucial element for the actual policy. Certainly, when talking about this has an effect that you do not talk about possibilities of an effective policy. So on the short term, I consider it not as a crucial element. But it can be on the longer term. But it's clear, and I think like Sophie put it already forward, it's clear that it only can be in the context of a more comprehensive approach, in a more global approach of asylum policy. And it's clear that it can be only effective if first there has to be done a lot more, but really a lot more about enforcing policy, enforcing the systems in the countries concerned eventually. And I'm then talking not only about enforcing the asylum system or the system of protection, regional protection or not, but it's clear then the system in the whole of these countries has to be enforced. So it means really that a more global approach has to be organized. I think later on we will discuss about it. And again, it's something that's easy to say, but not easy to develop really. The only thing I can say that it can be only effective if a lot more first has to be done in the direction of these countries. So this means that to be effective, the European Union, the member states, have to work out on the short term a policy within the frontiers, the borders of the European Union. And this, in receiving asylum seekers, working out policy of saving people, but working out an effective policy of control, border control, but this, and it's clear to me, linked to an effective asylum system.
Thank you. The issue of the border controls brings me to the next two questions that we have, the way in which people arrive here in an irregular manner or regular manner. There has been a lot of discussion of people, and reference has been made who aren't even allowed to step aboard from ships in the European, to debark from ships in member states of the European Union. The fact that people who do arrive in an irregular manner, some of them are entitled to protections, others are not. How are you going to deal with that? Certainly if there's a concentration in certain points. And together with that, in order to avoid these irregular movements, are there possibilities to go more towards the direction of what's being called legal pathways as an alternative for irregular migration? Perhaps also your thoughts on this issue. Is it realistic to set up these so-called control centers that would make a first screening between those who are and those who are not entitled to protection, and then split them up between asylum and then probably irregular migration and return perspectives? And secondly, if we do not succeed in doing that, can we set our hopes on legal alternatives like the reference has been made to that, the sponsorship schemes that have been installed? Perhaps Dirk, to allow you to take the floor first and not to have to repeat the others, because...
Okay. Thank you. Now, a lot of points also. It's at the same time about control centers and legal pathways as an alternative of policy about irregular migration. So, but I think that and like I ended in a way, so to come to a more effective policy and a more solid asylum system at the same time, it is very important to come to a more, how to say it, a controlled situation. And that is that member states can make clear that they take over again control of migration. And this is important to come to an effective system, but I consider it also as important to come and to have, how to say it in English, to have the support of people for it. So to make clear that you take over control again. I consider it as a very important aspect. And in that perspective, like I said, it is only at this moment realistic to come to a more controlled situation, organizing this system within the frontiers, the borders of the European Union. Like I said, answer to the previous question, to externalize it at this moment, it is not realistic, and independent of the question if you want to do it, if it is opportunist, but it is not realistic. So, and then in that context, the organization of control centers can be and maybe is an important aspect, because it is important to organize then border control, but an effective border control is more than only organizing border control. And organizing and maybe looking after who is arriving, who is coming in. So, and at every frontier, not only on the frontier, people arriving by the Mediterranean Sea, but at a lot of other places. So border control is also then, if you see that the people cannot enter the country because has not the papers and is asking for asylum, so that you have to organize immediately, eventually linked to the border control, the assessment of the situation. This is very important, and it is also necessary. One thing, pushback is not allowed, and it's also not possible, and you cannot defend it also. Let's make clear that. So you have to organize this, linked to border control, and immediately an assessment of asylum system. And this means, I think, then necessarily, in a way, linked to border control, you have to organize that asylum system, and you have to come to more than now, and you can name it like you wish, controlled centers. And I think it's necessary, to come to the organization of these centers, but again, it will not be easy. So if it will take a lot to come to organize this, and between colleagues. So director generals responsible for asylum system, we have already been discussing about the point, if they will ask us to organize it, how will we do it? So we and because that's and what sort of conditions, and then we make a list of a lot of things, of all the managerial problems that, and it's a long list, and it has come. Okay, we can do it, but a lot of conditions has to be fulfilled. And again, it's sometimes, and we will, and a remark of many of us was, now, politicians work on an idea without asking first to those who have managerial experience, how can we do it? How will it be possible? Under which conditions? And so on. And at this moment, it's clear that it will not be easy. And it will not be easy managerial point, but it can be done. Maybe this will be more difficult. It will also not be easy, maybe, on the political level. And certainly, on concerning the question, and where will these control centers have to be organized? Near the border? Yes, in principle. But then, and this is at least a very important aspect in this, it's clear that at the same time, and it's necessary to come and to work out mechanism of solidarity. Because certainly, when you see that some countries, and more countries in the south, will be confronted with a higher burden than others. So it's clear that mechanism of solidarity has to be worked out, effective. And I think that at this moment, not only mechanism about solidarity, about the assessment, yes or no to relocation, but also mechanism of solidarity about the eventually return of persons for whom instances came to the conclusion there is no need of protection. Again,
The
it's easy
second
to say.
And on the legal pathways, also from your experiences with some of the schemes that we've had in Belgium.
Now, on the legal paths, it's very short, so I think that I defend legal pathways, and I think these are important, but then at that moment, as a solution for some persons, and in the context of organizing protection and so on. But I also think that, certainly in the actual context, legal pathways as an alternative of a policy of control of irregular migration, that's an illusion. So that's you still have on the same way to work out a policy about control of irregular migration. So it can be in an element to give a solution to persons in the context of a policy of giving protection or for other reasons. And it can be an element in future, maybe, and then on the longer term, in a more comprehensive approach, as an element in working out an alternative of the policy of irregular migration. But on the short term, it is not to be considered, and it's an illusion to present this as an alternative for a policy of irregular migration.
Steve?
Thank you. And maybe I'll start with the legal pathways point, since Dirk just finished it. I think I very much would agree, would share your analysis, Dirk, of the importance of legal pathways. I mean, this is a broader discussion that we can have. Legal pathways, especially when it comes to persons who are in need of international protection, have a very important place. And I think what the European Union has been seeking to do is to move from, as I said earlier, a situation of our refugees arriving via irregular routes, that they should be coming via resettlement primarily, and that allows us to identify the most vulnerable people, the people that UNHCR identifies as being in particular need of resettlement, and so on. So it is definitely a very good thing and a worthwhile thing, and that's the direction in which we should be going. But I think we do have very good reason to be skeptical about the impact that creating legal pathways, which will always be necessarily limited, will have on the incentives for irregular migration, even of persons in need of international protection, because those numbers of available places will always be limited. There will always be an incentive, I think, for persons to seek to arrive irregularly. So I think we have to be careful about that. I know there is a narrative there, and the Commission is also guilty of that, of making this linkage and somehow saying that this will provide a disincentive, if you like, for persons to come irregularly. I think there may be some impact on the margins there, but it's not going to be a significant impact. Where there can be an impact, though, and that is something to put in the context of the more global migration management points that we were discussing earlier, there can be an impact on the provision of legal migration paths in terms of the incentives of third country governments to cooperate in discouraging irregular migration. Just give you an example. If the European Union were to offer to Senegal, for example, just as a state, that there would be every year several thousand places available for skilled workers to come here, students to come to the European Union. This could be something that would incentivize the Senegalese government to explain to its own population about the dangers involved in seeking to migrate to the European Union, maybe even taking some practical measures to break down smuggling networks or whatever. So I think it does have a role in that sense, but we think we have good reason to be skeptical about the direct impact that it has on disincentivizing irregular migration. Then to come back to the first point about controlled centres, and there I think I would also very much agree with Dirk that this is something that is important. It is important for public confidence, but also for a sustainable management of migration flows, especially when it comes to large-scale arrivals, unexpected numbers, large numbers who arrive by search and rescue, to be able to control that and to be able to manage it in an efficient way, also in the interest, I think, of the persons themselves arriving. It gives them more rapid access to protection if they're really in need of protection, provides the possibility then to identify those who clearly are not, and return procedures can start. And I think it can also facilitate solidarity being used internally within the EU in terms of relocation, because there would be, I think implicit in that, there would be a guarantee that there would be restrictions on secondary movements, and other member states would feel confident that in those circumstances it would be reasonable to relieve the burden of the frontline states to a certain extent. The form in which it will take, I think there we need to be flexible. There was language in the June European Council conclusions, which I think is the reason why we're discussing it, actually, this kind of enigmatic language there in the Council conclusions that we spent some time trying to decipher and understand. I think in the end we concluded, let's be pragmatic, let's interpret it in a sensible way. I think the Commission produced a paper there in July to explain that it's not intended to be a sort of one-size-fits-all straitjacket, that there are different ways of doing it. It can be, for example, that these centres would be closed centres or open centres or partially open, partially closed. The kinds of procedures that would be used there, they could be different kinds of procedures that, you know, every situation, every country in which they're established would need to fit the model to the one that suited the challenges they're facing and the legal framework that they have themselves. Here again, I also think in terms of, you know, there is a sense now maybe in some quarters that this has been somehow another one of these failures to implement something that the leaders have come up with. There, I would not be so negative, actually, because I think this kind of model is one that has a value and probably will be implemented in some form in the future. It's not a new idea either, and I think Sophie knows very well the UNHCR itself actually proposed model along those lines a couple of years ago in a very thoughtful paper that UNHCR produced. So it's not something that is, I think, to be viewed negatively, and I think it is inevitable that we will move in that direction. Not inevitable, but I think it would be a good thing if we move in that direction in order to better manage the kinds of arrivals that we sometimes have in the Mediterranean, with large numbers of persons arriving on boats and being disembarked. The kind of things we've seen this summer actually show that, you know, there really is a place for that kind of model.
Okay, thank you, Sophie.
Thank you very much, and I'll try and keep my comments very short because I can see we're running out of time. These two remaining questions, I think, really highlight why a comprehensive approach is so important, because neither of these questions can be answered on their own in isolation. Their success will be dependent on other things also functioning well. Taking the first one on the controlled centres, as Stephen was rightly saying, the use of that wording was rather enigmatic, but we have indeed, as UNHCR, called for properly managed processes, that when people arrive they are immediately registered, that there is a very quick triage process to try and identify cases that would be manifestly well-founded or manifestly unfounded, and that we have proper procedures that can respond to the protection needs of people arriving, quickly identify who is in need of protection or not, and facilitate onward integration or onward return or readmission as necessary. We think that it's crucial that these systems are functioning for persons who are in need of protection so that they can quickly get that recognition and proceed on to integrate and rebuild their lives. It's also fundamentally important for the preservation of the institution of asylum that we are able to demonstrate that asylum procedures can work. There are many voices out there that are saying that this institution is unworkable because of the constraints of human rights law. We would rather say that it is workable because of the standards that are there, and we need the political support to make sure that these systems work. Ultimately, we need to have the support of the citizens of the Union behind good institutions for asylum so that we can push back against some of the populist voices that we have seen recently. And it's important that we do what's necessary to preserve those institutions. In order for proper registration to work, states are going to need a reassurance on solidarity. We have seen that no countries have stepped forward and volunteered to run a controlled centre. And at the essence of these issues are that states are unwilling to invest in running properly managed systems if they have a concern that they will be left to deal with this system on their own, that they won't get support from other countries. So this question is intimately linked to the need to have a predictable and functioning solidarity mechanism across EU member states. The other thing that it's fundamentally linked to is quality procedures and harmonised procedures across the European Union. We do hear a lot about onward movement, secondary movement, and as Stephen rightly points out, these issues need to be addressed in order for proper management on arrival to work. We would like to see the focus on addressing those issues on why we have onward movement in the first place. And it's quite clear that a diagnosis demonstrates widely diverging recognition rates across the EU member states is potentially a big trigger for onward movement. So long as we have diverging recognition rates from nearly 100% for Afghans in one country and nearly zero in another, we're going to have onward movement. Where we have highly diverging quality of standards in reception centres, and where asylum seekers, even in some EU member states, can't access the basic reception conditions they're entitled to, we'll have onward movement. So we would like to see a focus on addressing the reasons why people feel compelled to move within the European Union. We need for properly managed registration to function, we need return and readmission systems that work. And we have to address that and make sure that we have quality decision making in place so that those procedures can follow. Then just moving quickly to the legal pathways, I think that we can also say from a UNHCR point of view that sometimes we can be guilty as well of saying that we need to have resettlement and pathways so as to try and reduce down the incidence of irregular migration. And the reality is that having resettlement and legal pathways is part of the longer term solution. It is not going to be the ultimate solution to reduce irregular migration, but it has a key role to play. In order for resettlement and complementary pathways to make this contribution, we need a couple of things. First, we need credible numbers. The European Union member states have made great strides, and we need to thank those member states who've done that, and the Commission also for coming forward and appealing to states to come forward with 50,000 places. These are really important measures, and they need to be seen in the context of arrival numbers of 8,000 and less about 4 or 5 years ago, and now we see arrival numbers in 1 year above 25,000. That's really big progress. Unfortunately, we need more progress. UNHCR estimates in terms of our Global Trends report that more than 1.5 million refugees are in desperate need of resettlement. It is a reality that other countries that used to be key partners for us in resettlement are leaving the stage, principally the United States. So we will need to see more states stepping up. We need all EU member states to get actively involved. We now have more than 20 EU member states involved. 8 years ago it was less than 11 or 12. So that's good progress. But let's look at one particular programme that we have at the moment, which is the emergency transit mechanism, where UNHCR works to transfer vulnerable refugees from Libya to Niger, with a view to resettling them on from Niger to other EU member states. Some EU member states have stepped forward, pledged places, and nearly 900 refugees have been resettled from Niger. But we have evacuated more than 2,000 to Niger, and we need all EU member states to step up. And if there are member states who feel that resettlement, is the way to properly bring protection to the most vulnerable, then why not step up and support the ETM? It's a good project, it's an innovative project, but we have, a handful of EU member states involved, and others need to get involved. Again, pathways and resettlement are not an alternative to protection in the European Union, and for the reasons that I raised earlier, I think that kind of messaging can be counterproductive. I should also note that those countries who have been lauding resettlement as an alternative to protection in the EU, some of them have recently stopped their resettlement programmes or will not commit to resettlement. Recently, Austria and Denmark launched an initiative to say that principally people should receive protection by way of resettlement and other pathways and not come to the European Union. But at the same time, they also announced that they would not be participating in resettlement. So, those things are relatively don't sit well together, and we need member states to step up. Other pathways must be complementary to resettlement. So refugees who are in need of resettlement should receive that, and other legal pathways, sponsorship schemes, community sponsorship, student visas should be on top of resettlement. So we don't want to see member states reducing their resettlement quotas to allow for other pathways. We need to do both together. And finally, if I could just mention the Global Compact on Refugees again, that provides for a 3-year study to be undertaken on how we can further develop resettlement as a tool into the future. And UNHCR is going to be working on that and entering into a consultation on that, and we'll be consulting with the Commission and Member States and partners on that to try and bring us forward to, I think, where we all want to go, which is that pathways and resettlement has a broader place in the protection environment. Thanks.
Thank you very much. You mentioned the Global Compact just briefly. It is going to be adopted probably by the General Assembly next Monday. Certainly here in Belgium, where we've been struggling through a political debate last week on the other Global Compact for regular migration, where demons were thought to be seen in that compact. This went relatively unnoticed. Either some politicians were asleep, or let's put it more positive, there's still hope for refugee protection, for asylum protection, when you see that this is going to be adopted. And is this a first step to a more global approach of the issue? Just a brief comment.
Yes, we think the Global Compact on Refugees has a really crucial role to play. The plan is that it will be adopted by the General Assembly on Monday. The compact is about trying to assist states to better respond to mass movements of refugees. It does not in any way touch the existing legal obligations that states have. Those obligations are set out in the 1951 Convention, and when it comes to EU member states, in the acquis. Rather, it tries to bring together a range of initiatives to improve our response to refugees and to try and assist states who are hosting them. So there is an action plan set out in the Global Compact which sets out some specific actions that can be taken. The Compact calls for more solidarity between countries when working together to host refugees. It talks about refugees being integrated into national programs so that we are, rather than seeing refugees as groups apart, we are assisting them within national societies to be part of national education systems, national health systems, so that we are assisting refugees with development from the first moment that they arrive, rather than leaving that solution to later. The Compact is about engaging with new actors, including in the private sector, to help refugees to become more empowered, to enter the labour force, to enter the workforce, and to start rebuilding their lives as quickly as possible. It's about new relationships as well with the World Bank to try and find additional ways for financing for countries that are hosting the vast majority of the world's displaced. It's about developing new initiatives on resettlement pathways, on complementary pathways that we need to see progressed. We would like to work together with partners when the Compact is adopted in its rollout. We very much welcome the contributions that some have already produced. Notably, ECRE has produced their own document on what the Global Compact on Refugees might mean in the European context. That's a really welcome contribution, and we look forward to engaging with them on that as well. So we will be entering into a phase where we want to try and unpack a bit more what the Compact means, and we hope to use this to build on solidarity globally to try and address these issues together with refugees, NGOs and member states. Thanks.
Thank you very much. Good, I'm looking at the time. I think we still have 10 minutes for some questions here. I want to give the audience the opportunity to ask questions. If you have questions, you can use your microphone, which is, I think, at the left-hand side, and you should push the button, I've been told. And if you could briefly present yourself and indicate to whom of the members you want to ask your question to.
Okay, so I'm a member of the Belgium EMN-NCP. As regards the controlled center, maybe a very practical question in case someone would arrive there and he's not eligible for international protection, but he can't be returned, for example, because there's no readmission agreement with the country of origin. What would be the following step? Would he be allowed to leave the controlled center anyway, or what would be the consequence in this case? And to put it somehow provocative, maybe, I hear Ms. McGuinness referring to a quick triage process, but isn't there like to say it provocative, if it would take a longer time and it could serve as some kind of dissuasion for people if they know that they will be stuck for a while on a spot where they don't want to be, that it could be as an element to avoid irregular migration also. So.
Thank you. Perhaps take some other questions. Yes. Push the button and yeah.
Thank you very much. My name is Ahmad Wali, and I work for Center for European Policy Studies in Brussels. My question is also about the control center. I remember last year there was an event at STEPS, and the opinion or the narratives of the UNHCR at the time was a bit more critical and negative towards this agenda, and compared to that time now it have changed a bit, like there are a bit positive opinion. Is it because of the political let's say political influence, or is because you have worked out since then and you realize that there could be something that we could work out of it? Thank you.
Okay, thank you. And then I saw another hand.
Yes, we haven't elaborated so much on the private sponsorships. I think there might be interesting for the integration of people, but how do we avoid the risk that they are the people who are chosen on with bias or with certain prejudices that exist here? I see the example that we've seen this morning is that mostly Christian minorities were chosen by Christian communities here. How do we avoid that? How do we make sure there's a certain objectivity in the choice of those who are allowed to come when we have private sponsorship?
Okay, thank you. Frank.
I have a question about the very different recognition rates in the different countries of the European Union. If there is any idea how this could be improved, why is it that there's such a different recognition rate? Peter mentioned some element, but he seems to be, as he mentioned himself, rather marginal to this different recognition rate. And I was also wondering whether Greece has been an experimental field where the European Union had more influence on recognition rates or not. Thank you very much.
Okay, thank you. We'll start with those questions. Perhaps Stephen, if you can start.
So I can try and take at least some of them. Perhaps just to start with the last one on recognition rates. Indeed, I mean, and this is, I think, something the Commission has also been guilty of to some extent, creating the narrative that somehow changing the legal framework, having more harmonization of the legal framework, will sort of magically result in an evening out, a convergence of recognition rate. It is, of course, a critical element of that, and we have proposed that the Qualification Directive be transformed into a regulation. But broadly speaking, I mean, the legal framework already enshrined the core elements of assessment, so all member states should be already applying the same legal framework. But of course, it's more than that, because it's the way in which it's implemented that really matters. And because of the nature of that, I think it's something where you're not going to see a magic overhaul of the quite divergent recognition rates, especially for some nationalities overnight. It involves multiple aspects. One is, ensuring that the member state experts who are assessing claims, that they're relying on the same information about the situation in countries of origin, that they're making broadly the same analysis of what that means in terms of the protection needs of groups of persons and then individuals who claim asylum. And there I think some important work is being done by EASO, for example, to ensure that member states are using the same information and analyzing the information in the same way, and is even moving in the direction of providing guidance that hopefully will mean that the assessment that's being made at the national level is broadly similar. And then the other aspect which is linked to that, of course, is training not just for the decision makers in the asylum authorities, but also at the judicial level, that there's a proper understanding of the way in which asylum analysis should work. Maybe to take up then the first question from the Belgian representative there, in relation to what would happen to somebody who can't be returned. They've come to a control center. I mean, these control centers, however they're modeled, they will still operate within the framework of EU law. So such a person, if they don't have protection needs, they're not going to be given another kind of status by the country. Then return proceedings will start. But of course, if it's not possible to return the person, then there would no longer be a ground to keep them in any kind of closed center. They would have to be released from detention, and that would be the right thing to do. And that is, I think, what would happen. I don't think you're going to see these centers being used as an indefinite holding facility for persons who can't be returned. It's only in order to maximize the possibility that they could be returned if they can, by assisting with making sure that the person is there, identifying them properly, then having union assistance in terms of contacting the third country that they would be returned to, and so on. But of course, in the end, if they're not able to be returned, then they have to be dealt with by the host state in the way that we see today. Yeah, perhaps the other questions I'll leave to others to answer.
Thank you very much. Maybe to start with the question from the colleague from the EPC who had one directly addressed to me as UNHCR. The strategy that I mentioned before about UNHCR's view on registration on arrival and triaging, we set that out in December 2016. So that's part of our comprehensive approach, where we say that 4 things need to happen. And one of those is a common European asylum system that works. And the first point of that is common registration of everyone who arrives, and a triage into accelerated procedures for cases that are manifestly well or manifestly unfounded. So that's been our policy on what should happen when people arrive in the EU as of 2016, where it was set out in some detail. The issue of control centres, as I said when I started my remarks, is undefined. What it means to people are different things. But UNHCR is quite clear when it comes to detention. If people, when they're talking about control centres, are talking about detention, we have a very clear policy in relation to detention. We have a global detention strategy, and we have a number of documents. And basically we say that children should never be detained, and that detention should only ever be at a very last resort, and only after alternatives to detention have been explored. So if the question that you have is in relation to control centres as places of detention on arrival for people, then we have a very clear position in relation to that. So what I was talking about was more well-managed registration for everybody on arrival. In terms of the where to go. The control centre, I mean, on the non-return issue, I think that Stephen's dealt with that very well. Of course, indefinite detention is not permissible under the EU acquis, nor should it be, and nor is it permissible under the Strasbourg jurisprudence. Again, this harks back to the need for a comprehensive approach. We need to have a better set of arrangements with third countries when it comes to return and readmission. And those discussions can only really progress with those third countries if we can have, let's say, a more open and respectful and inclusive dialogue with those countries concerned. There has been a lot of outreach from member states and from the Commission. Some of it is very well perceived, and some of it is perceived not in the best light. We have to try and work with third countries in a way that engages with the issues of concern to them. If we look, for example, in certain countries in West Africa, we have an absence of basic registration systems in those countries. We have some countries where people, only a small proportion of the population have access to ID cards. From what I saw in most recent figures for the 300 million people in the ECOWAS area, less than 30% of them have an ID. So if we want to address things around return and readmission, we need to also look proactively at capacitating other countries to develop the required systems. And we need to look at the development of those systems not only through the lens of return and readmission, but also through the lens of trying to avoid issues of statelessness which arise in countries where there is no proper birth registration or registration issues. So to the issue of a person not being able to be returned to a country, I would highlight, as we highlighted in our December 2016 document, the situation of stateless persons who cannot be returned, and there have to be solutions in relation to them. In relation to the question on improving recognition rates, there are a number of initiatives underway. Stephen has mentioned some of those, but I agree that it is about implementation at the end of the day. There are a number of quality initiatives that UNHCR rolled out in EU member states from 2012 onwards, and we handed over our work on quality to EASO, which is taking that forward. And we would appeal to all of you who work as EMN focal points in your countries to perhaps try and do what you can at national level to encourage the decision makers at national level, both first instance and second instance, to put in place robust quality procedures in those countries. You know, it's a very important thing to do, to take a proportion of the numbers of cases decided at first and second instance level in your countries, and to do a quality check for them to check that they are being properly determined. I think that is one of the best ways to try and make sure that quality decision making happens, and that we can try and get some harmony in recognition rates. And finally, on private sponsorship, one of the things that perhaps we could suggest on that is a project that was recently concluded by UNHCR, ICMC and IOM on complementary pathways, and 7 guides were produced as a result of that, including on community-based sponsorship, and it deals on a step-by-step approach, how to approach the issue of community sponsorship, how to deal with things around selection, around cases, and I think there are some very useful tools in there to try and guide that discussion. Thanks.
Okay, thank you. Perhaps on the interpretation and the divergence in interpretations from the field, how do you prevent that from happening?
Now then, I think you're ready, so I can talk about it hours. So I will limit me to 1 hour. So no, a few minutes. No, I think about differences in recognition rates, there are a lot of things to say. And I'm now speaking out of experience of what I have what I've seen past years, so in contact with colleagues, and certainly working also in EASO. And there are a lot of factors playing. It's true that one factor is that there are differences of profiles in member states. In some member states, for instance, because some people, for instance, from Afghanistan coming from a very specific region, and that are not going to another member states. So this is an element. Another element, and that is, there are still differences in interpretation of concepts, even when sometimes criteria and guidance are clear. And I'm just giving now a very specific and clear example. I think UNHCR can confirm it. When we are talking about Afghanistan, for instance, then there is still a clear difference in the interpretation of the internal flight alternative. And the possibility, in case of persons for which a need of protection is stated, and taking count of the situation in a very specific part of the country, and that they come, and then there is the question if there is yes or no a possibility of the internal flight alternative to another place in Afghanistan. In some member states, they still come to the assessment, to the conclusion that in general, there is a possibility of internal flight alternative to Kabul. And I say in general, not necessarily for minors and even not for families of children, but for all the others, in general, there is. While in Belgium, since longer there is this, it's not in general. It's after a check of the individual situation, network, and so on. And there has been long discussions within EASA about this topic. And I have to admit, there was no possibility to come to a clear conclusion then, and then you come to, in the guidance, a general statement that lets open still a lot of space for interpretation. So there are still differences in the interpretation and the assessment of situations. And it's clear that, and that we still have to go away, and this under pressure maybe of jurisprudence, but also in discussion about member states, experts of these. But there are also other elements, and I will just limit to a last element, it's not only a question of the interpretation of concepts. A very, very other important aspect is the way the assessment is organized, the way credibility is assessed, and so on. And in many times, this is more important than the interpretation about concepts. For instance, the country with 100% recognition rate for Afghanistan, it is simply because they do not an assessment that they come to that conclusion. In a way, they only say, yes, people is coming maybe from Afghanistan, so we will give him a protection. So in that country, there is not really an assessment of the credibility, even not maybe of the origin of the persons. This, a few words, so but there is still a way to go, and I believe step by step, certainly on this aspect, we will come.
Good. Thank you very much. I would like to thank the members of the panel for sharing from their very rich experience, their insights in some of these aspects. We could talk about them for hours and hours more, but thank you very much for participating here in this panel discussion. Thank you.